Good evening, this is John Milburn for Laws 12063. This is Advanced Statutory Interpretation and Drafting. We're into week 9, getting down to the business end of the term. And tonight we'll continue where we left off last week. So we're still looking at the Acts Interpretation Act, in this instance Queensland, and I'll share the screen. And if you're working with me, either live, Nicole or Nadine, or in a recorded session, or watching a recorded session, would you also please follow the legislation as we proceed? So this is the Acts Interpretation Act, and that's the Queensland provision. We're going down to Part 8 that deals with terms and references in Acts. Part 9 is also relevant. These, of course, are relevant for your assessment piece, in that when you draft material, you need to be acutely aware of these requirements and presumptions. Let's start with section 32C, dealing with number. We touched on this, I think, last week. And 32C simply says, in an act, words in the singular include the plural and vice versa. Now, you'd think that that would be extremely simple to interpret, but it is a presumption which can be rebutted in appropriate circumstances. And when we read legislation like that in isolation, without thinking about other factors, it is easy to fall into a trap. So an example of where the presumption was rebutted was Blue Metal Industries against Dilly. It's a High Court decision, 1969, 117 CLR 651. In the context of a company takeover legislation, the court rejected the claim that the singular, as in one company, included the plural, as in a group of companies. So thereby, that presumption in 32C would be overtaken, or rebutted rather. Let's look at a more recent example and the case of C&E against CMC Brisbane. This is 2004 Queensland Court of Appeal 60. Now this case dealt with building contracts, and the contract was for the construction of 10 separate homes. Now the question was whether it was a regulated contract under the relevant legislation at the time. Clearly then the discussion was around singular and plural. Let's have a look at paragraphs 16, 17, 20 and 21 of the decision. So Court of Appeal, the decision of Justice McPherson, provides at 16 that a key question: is it a contract for the construction of a detached dwelling? The question on the form suggests it's not. There are 10 houses, not one, that are to be built under the contract. But this is to leave out the operation of section 32C of the Acts Interpretation Act, which is singular includes the plural, etc. So the question was in relation to sections 7 and 8 of the then current legislation, the Domestic Building Contracts Act, and should it be read as including a contract for a number of detached dwellings. At paragraph 17, the presumption of plurality, if that's what it might be called, created by section 32C is, however, and this is a key part, subject to section 4 of the Act, which provides that the application of the Act may be displaced wholly or by contrary intention appearing in any Act. So that's a really important provision to remember, that anything that you read in the Acts Interpretation Act is subject to that which is stated in section 4 in relation to the displacement wholly or partly by contrary intention. If you're involved in drafting legislation, you need to keep that in mind. If you're acting for someone, for example, in defence of a prosecution, you need to consider whether, by reference to extraneous means, extrinsic materials, that you might be able to mount an argument that even though the prosecution case appears to be black and white, when you consider the context and other circumstances, it may be that that clear statement is displaced by contrary intention. At paragraph 20, the court went on to say that Section 4 enables, this is the third line down, the presumption created by Section 32C to be displaced by contrary intention appearing in any act. And then we look at Section 21, paragraph 21 rather, to say I find nothing in the act that demonstrates an intention to displace the interpretive presumption created by 32C. Then we have the court referring to textbooks, including the author of your text, Professor Pearce, where the authorities discuss and suggest that the provisions have not always been enthusiastically applied by the courts. That is, the provisions that are counterparted to Section 32. Let's go back to the Acts Interpretation Act and have a look at Section 32CA. Now, the case that's relevant to 32CA, which is that which talks about may and must being discretionary or mandatory, if you like, is the Attorney General against Holly, 1996 QCA 480. So this was an appeal by the Attorney General, and it raised before the court two questions in relation to Section 147 of the Penalties and Sentences Act. So Mr. Holly was placed on a suspended sentence. And during the period of the suspension, he was charged with further offences in relation to which he breached bail. So the court was dealing with the breach of bail, and consideration was whether it also had to deal with the breach of the suspended sentence at the time. Now, Section 147 of the PSA spoke about the court dealing with the offender for a suspended imprisonment and saying that the court may do one of a number of things: extend the operational period, order the offender serve the whole of the suspended sentence, or order the offender serve part. Now, the argument before the court in this case of Holly was whether the course whether in the course of dealing with the matter, they were entitled to take another alternative, and that is, by reference to the permissive may, take no action. And defence counsel referred to Section 32CA, submitted that the word may in Section 147 of the Penalties and Sentences Act meant that the court had a discretion whether to act under the section at all, or alternatively, simply adjourn the matter. So the court again said that when you're reading Section 32CA, it must be read in conjunction with Section 4. And in this case, the court said that it's not possible to read 32CA3 as impliedly containing an exception to the general proposition in Section 4. And the court said it may, in the end, it must be remembered that it would be very easy to have said must instead of may if that's what Parliament had intended. So the argument by the Attorney General does not demonstrate a sufficient reason for departing from the prima facie rule that may confers a discretion whether or not to make the order of the type described. So that's the decision of Holly and 32CA. Have a look also at 32DA, the meaning of de facto partner. 32D, reference to persons generally. 32DA is the meaning of de facto partner. And a case relevant to that is Spencer against Burton. And in Spencer against Burton, Sharon Burton died of cancer on the 6th of July 2012. She was 56 years of age. And a month or so, a couple of weeks later, Mr. Spencer obtained letters of administration on intestacy with her estate, claiming that he was Sharon Burton's de facto. Now, in December of that year, Sharon Burton's mother, Daphne, filed an application and she sought a declaration that Mr. Spencer was not a spouse or a de facto. She sought her own letters of administration on intestacy, and she sought an order effectively revoking the earlier order and replacing her as the person with the lawful power under letters of administration to administer the estate. Now, on appeal, the argument was that the judge at first instance had not established on the balance of probabilities that the appellant and the deceased had lived together as contemplated by reference to section 32DA of the Act. And on the facts, the Court of Appeal actually accepted the appellant's argument in this case. All right, so the appellant being Mr. Spencer. So that's another good example of how this section might be used in a practical sense. While you're looking at the material, also consider section 36 that deals with the issue of commonly used words or phrases. And then go on to part 9. And part 9 deals with distance, time and age. There's only 3 sections there, 37, 38, 38A, and it provides for some machinery provisions. Then have a look at part 11, which deals with offences and criminal proceedings. And 41 provides that the penalty is referred to at the end of a section. And it basically says that you can't go beyond that penalty. And 42 is interesting. I'll share the screen for this because it's underutilised in many ways. And hopefully you're now seeing section 30, you're now seeing the Acts Interpretation Act. Have a look at section 42, which says that any person may prosecute. So you might have to think about this if you're drafting material as part of your exercise that calls for the possibility of prosecution. Do you wish to ensure that any person may take proceedings for the imposition or enforcement of a penalty or the making of a forfeiture order under an act, or do you wish to exclude that? Let's have a look at an example, again, fairly recent. P against H, 2018 to QDR 32, and you'll see that that is the reported citation. What's interesting is that the unreported citation was actually 3 years earlier, 2015 QSC 351. So you'll see from that that sometimes it takes a good deal of time for reported decisions to make it to the authorised reports. So what happened in P against H? So H was a police officer, and during the course of his duties, he shot and killed a man. The matter went to the coroner's court, and during the coronial inquest, the coroner found that H had reasonably believed his life was at risk. A man was pointing a replica gun. Although one witness denied that the deceased had anything in his hands at the time, the coroner found that evidence to be unreliable and inconsistent and found that H had acted in self-defence. The DPP didn't bring prosecution against H. Now, here's the interesting part. By way of private complaint, the deceased man's father, P, charged H with murder, and in the alternative, manslaughter. So the matter went before the magistrate's court, not as a police prosecution, as a private prosecution for murder. And H, through lawyers, made an application under section 102C of the Justices Act, and the magistrate dismissed P's complaint on the basis that it was an abusive process. So P then appealed to the Supreme Court, and in this instance the appeal is by way of hearing de novo. His Honour Justice Applegarth heard the matter and said that whilst there may be a public interest in bringing a private prosecution, where prosecuting authorities, the DPP in particular, have been shown to be capricious or corrupt or biased in their failure to refuse to prosecute, this was not the case here. And while a party may have an actual belief as to the correctness of their cause, this does not make a proceeding that is hopeless any less vexatious. So an abusive process may include circumstances in which a private prosecution is a hopeless one, or at least so lacking in prospects of securing a conviction at trial that no prosecutor acting in accordance with duty would persist with it. So that's a really interesting take on the Acts Interpretation Act. So keep that in mind if you're dealing with issues around a person prosecuting or not. Also look at section 44 of the Acts Interpretation Act that deals with the issue of summary proceedings. Section 45, which deals with offence punishable only once. That's all that I propose to talk about in relation to the Acts Interpretation Act, and we'll move on to some other material. No questions at this stage? All good? All right. Thank you. Now let's talk about chapter 11 of your text. And chapter 11 deals with obligatory and discretionary provisions. This is a chapter that you need to read very carefully, and there's some discussion there about obligations, rights, prohibitions, when some commentary about when provisions apply, when they don't apply, and how they might apply in different circumstances, particularly if we're dealing with the discretion between, or the distinction rather, between criminal and civil legislation. So whenever you're considering drafting material, you need to consider a wide range of things. And when you're undertaking this course, this exercise, you're changing your role from reading legislation to writing a statute. So the task for you is to consider whether you're properly able to interpret statutory provisions so that you better understand the tasks that are faced by the drafter of that legislation. So have a look at both Chapter 11 and the Commonwealth Office of Parliamentary Counsel Drafting Manual, which I think I've referred to previously. So the primary case, when we're talking about obligatory and discretionary provisions, no surprise here, Project Blue Sky against ABA, 1998 194 CLR 355. And you'll recall that in that case, the High Court engaged in the careful process of interpreting a statute in light of international agreements between Australia and New Zealand. So when we talk about the operative section, we're talking about that part of the statute that focuses on the mischief towards the to which the Act is directed. And it tells people an operative section goes to the heart of a statute. And when we talk about operative provisions, we're really talking about those provisions that are contrasted to machinery provisions. So an operative section tells people what they have to do, what they must not do, and it will often contain conditions. So the basic models, and this is in your text and your notes rather, is this. So you must do something is the basic phrase, but you can then add to that by different things. You must do something if a condition, or you must do something unless a defence, or you must do something if condition, unless defence, and so on, so that you can build some progress around those basic means of building blocks. So the first thing you need to do in looking at each operative provision is the subject. So the subject of a sentence is the person or the thing or the concept which is performing the verb. So the subject is the person bound by the provision. The commentary goes on to talk about duties and powers at 11.3. So what I'll be doing is effectively providing a brief summary of section 11. So feel free to follow along as we go. So section 11.3 deals with duties and powers, so that if a court is satisfied as to the purpose or the object of the Act, then it will rule the provision is obligatory in certain circumstances. So again, have a look at 11.3. An example there is in re M. It held that the Registrar General of Births, Deaths and Marriages was obliged to correct the register upon receipt of proof, even though the Act said the Registrar may correct errors. So again, what's the lesson here? When you're drafting material, you may intend for an organisation, for example, to have a discretion as to whether to do something or not. But if you look at re M, the wording of the Act was discretionary, but the court held that the Registrar General had an obligation to correct the register. So we're really talking about that distinction between that which is mandatory and that which is directory. Lawyers distinguish between mandatory and directory rules. The basic tenet is that breaching mandatory rules will invalidate the process to which they relate, while breaching directory rules does not necessarily have that same effect. The example in your text is Disher and Disher from 1965. It's 11.4. And a statutory provision is that said at the conclusion of the evidence for the complainant, the defendant may address the court, was held to be permissive, may, relative to the defendant. But here's the interesting part. The court held that it was obligatory, relevant to the court. That is, if a defendant chose to exercise a right to address the court at the conclusion of evidence, then the court was obliged to listen and consider the address to it by the defendant. So in re-em and Disher, we have two cases that at first instance would appear to provide the subject, the Registrar General and the court, respectively, with discretionary power, but the courts disagreed and held in relation to them that it was mandatory that they perform. Now, that's at one level. I guess another level is whether the legislation that you might draft includes discretionary powers for public officers. And problems occur when a statute provides that public officers may or may not act in certain circumstances. So we consider the case earlier, P&H, where the DPP chose not to prosecute as a result of a discretion. So the preferred approach is always that the public officer would make a decision, even if it's mandatory, after giving due consideration. So we're getting into administrative law here. In other words, if a public office holder has a discretion there's generally an obligation to at least weigh up that material presented to them, consider the advantages, disadvantages, consider the consequence, and then make an informed and balanced decision. Again, that's the authority for that, which is in your textbook, is West Australian Field against Game Association and Pearce, 1992. Now, the provisions that require the exercise of jurisdictional powers are usually obligatory unless there's a clear indication to the contrary. Have a look at 11.5 and 11.6 that deals with number of cases where provisions were held to be obligatory in 11.5 and at 11.6 where the court held that they were discretionary. Sorry, 11.15, 11.16. A whole list of cases there which are useful. All right. Again, consequences determining interpretation. Have a look at 11.9. Reference there to Project Blue Sky. Have a look at paragraph 91, which is reproduced. And it says, an act done in breach of a condition regulating the exercise of a statutory power is not necessarily invalid and of no effect. The existence of the purpose is ascertained by reference to the language of the statute, its subject matter and objects, and the consequences for the parties of holding void every act done in breach of the condition. So note that last part. The existence of the purpose is ascertained by reference to the language of the statute, its subject matter, and consequences. So that's really important. If great inconvenience or injustice follows from strict compliance with provisions, you'll understand that courts are disinclined to hold that that imposes an obligation. Again, have a look at your text and look at 11.19. And the authors referred to an example, Simpson against the Attorney General. And that's a useful case to highlight the what this is all about. So the provisions of the New Zealand Constitution relating to dissolution of Parliament said they did not have to comply, they weren't necessarily complied with. And the result of the finding was that strict compliance was necessary. If it was necessary, it would nullify a huge number of acts of Parliament. The court considered, notwithstanding the fact that the Constitution used the word shall, the provisions were directory only, not mandatory. And the result of holding that they were mandatory would have created extraordinary inconvenience that served no purpose. Recently, we had a decision of the courts in relation to the Mental Health Review Tribunal, where it was held that a particular member was not properly authorised to sit in the tribunal, and that created a lot of difficulties. So when you're looking at this whole issue of may and shall, mandatory versus directory, it's not quite as easy as you'd think at first instance. So bear in mind the general principles, bear in mind that which is in the Acts Interpretation Act, but do consider the wider context and the way in which this might be attacked. The commentary then goes on to talk about words to that effect. So a similar approach applies to the requirement that certain statements be made. So a statement to like effect might be sufficient. Have a look at the case of Samuel Montague against Swiss Air Transport, again referred to in your notes. It's 1996, to QB 306, where Lord Denning said that the exact words for air consignment notes could lawfully be replaced by words to that effect. So sometimes we don't even need the precise words. So that's where you need to potentially consider the whole aim of the Act and determine whether it would have been defeated if a provision was not complied with strictly. So the example there is WMC Resources against Lane from 1997. Then go on to look at paragraphs 11.22 and 11.23, which deals with issues around private action more likely to produce invalidity than public actions. The example there is Hunter Resources in Melville, where a requirement for an applicant for a mining licence to peg the claim required strict compliance. So the commentary here basically is along these lines, that the courts are more likely to be strict where there's a positive obligation imposed on an individual than a public authority. And I guess we saw a reflection of that in relation to the Simpson and the Attorney General case from New Zealand. Now, contrast what the court decided in Hunter and Melville with the decision in Clayton and Heffron, which is from 1960. So it was to do with the procedure for passing a bill, and the court held that the performance of the public duty upon which the task is confided is such that a deviation that would cause inconvenience is a powerful consideration. Again, Simpson concept there. All right, go on to 11.24, dealing with provisions setting out protections for persons affected, and that will usually result in invalidity if there's non-compliance. So where the provision sets out the requirement intended to allow people to make representations relevant to a decision, or to review something or oppose something, then failure to comply with requirements will usually be interpreted as producing an invalid result. So courts require strict compliance with notice requirements and giving of reasons unless there's a clear indication in the relevant legislation to the contrary. The relevant case there, which is a planning and environment case, Skur against Brisbane City Council from 1973. Then go on to look at 11.25, which deals with enactments relating to court procedure. Courts will consider whether there's any real inconvenience or injustice that may flow from failure to comply with procedural provisions. In other words, just because something is stated to be mandatory, the court will consider the consequences. So the tribunal has power to determine its own process and time limits. So time limits is dealt with in 11.26, and you'll see there that the general review of the courts is that non-compliance with enactment laying out procedures will result in invalidity, but courts will consider whether there's any real inconvenience or injustice that flows as a result of failure to comply with those provisional or those procedural provisions. So you're seeing a theme here, aren't you? That the courts will often look to the consequences and consider the degree or otherwise of inconvenience and injustice that will flow. Right, so time limits, 11.26, impossibility of compliance, defence to obligatory requirement, which is 11.28. Courts will often exercise strict compliance where compliance is not possible, and a rationale for this approach is to indicate that where the compliance is not possible, that would indicate that the requirement cannot be obligatory. Then go over to 11.29, waiver of rights under obligatory provisions. So a provision will impose an obligation on a person or body for the benefit either of the person or the public at large. So if it's clearly for the benefit of a particular person, it seems reasonable that the person should be able to elect not to require strict compliance with that section, and courts will adopt that approach. But if the section imposes an obligation of public interest, courts will generally not allow waiver of an obligation. So when you're, again, drafting your material, think about whether it would be possible for someone to waive the requirement if you impose a requirement in your mock legislation. Compliance with forms is 11.30, and that goes through to 11.36. So legislation often prescribes for a particular purpose. In that regard, have a look at Section 25C of the Commonwealth Acts Interpretation Act. And it says that where an act prescribes a form, then unless there's a contrary intention, strict compliance with the form is not required, and substantial compliance is usually sufficient. Keep that in mind if you have an argument with the regulatory authority and a person who, in your view, is being overly pedantic in relation to the use or otherwise of a prescribed form. Now, each case, according to the commentary in the text, will turn on its own facts, and it's a matter of determining whether or not there has been substantial rather than partial compliance. And it may be that legislation did not intend to have any adverse consequence to follow from breach of a statutory procedure. So think about that aspect as well. So an example again is Skur against Brisbane City Council. So in Skur, a proponent for a development failed to provide adequate particulars in the proposed development, and the court held that that was contrary to the town planning scheme. It was not strict compliance. But there have been many cases where courts have declared valid actions taken, even though they were only partially compliant. So lodging a required deposit with a court 13 days after notice of appeal instead of 7 days was held to be sufficient compliant. Failing to comply with all aspects of procedure by a prosecutor on criminal proceedings at a committal did not necessarily result in the invalidity of the proceedings. Now, courts may not strike down actions undertaken where there's been a failure to comply with statutory procedural requirements. In the text, you'll see the decision of Australian Broadcasting Corporation against Redmore. This is at 11.34, and it's a 1989 High Court case. So what happened in the ABC against Redmore is this. The ABC failed to obtain ministerial approval before entering into a contract, and that was required by its enabling legislation. And the court rejected ABC's later claim that it was not bound by the contract because of this failure. So the court said that non-compliance with the Act did not render the contract illegal or unenforceable. The legislation was a direction to the ABC, which, if it was not complied with, may have consequences for the ABC or its employees, but the contract itself was not affected. And again, looking at the Project Blue Sky, which is referred to in 11.34, you'll note a similar approach was adopted by the High Court in that case. So in making a broadcast standard, the ABC did fail to comply with the statutory directive. The court said it was not the intention of the Act that the standard should be invalid. It was still a breach of the Act, and a person adversely affected may seek appropriate remedy to prevent the standard being enforced against it. All right. The final very short part of that chapter is the de minimis approach, 11.36, which is basically minor variations from the requirement, if they're trivial, should not be taken into account. All right, so what do we take from all of that? There are a number of options available to courts when considering arguments around mandatory and directory requirements. Courts could ask for strict compliance, or the courts could seek substantial compliance or that argue and find that the compliance is not a precondition to action taken. So the first two would result in invalidity, but there would be no such consequence for the third approach. So the courts adopt a certain process with this. What they do is the court will consider the relevant statute as number one. Number two, the court will not obtain much assistance from the terms of other statutes in many instances. Number three, the task is to determine whether the legislation was intended to be such that a failure to comply with the requirement should result in invalidity of the act done. And number four, once the legislation is construed, consider the result of non-compliance by reference to that construction, which is Project Blue Sky. I've been doing a lot of talking, but that concludes my helicopter view of Chapter 11 of the text. Really interesting chapter. I hope I've done it some justice. I fear I haven't, but it is certainly worth considering within the context of the drafting work that you have to undertake. Now, the formal topic for week 9 relates to exclusion, defence, and machinery clauses. So in this topic, we deal with each one of those things, and we consider about issues about drafting exceptions and defence provisions generally. So there's no prescribed reading. You won't find specific material in your text on that point. But what I'm going to do, as is often the case, is refer you to the Office of the Parliamentary Counsel. All right, so now we're dealing with very much issues to do with drafting of legislation. Remember the aim. When you're looking to draft legislation, the modern approach is that you avoid, if you can, complexity. When I read your assessment work, if I can read it and it's simple to follow and I understand it straight away and it's not too complex, then that's great. So please don't fall into the trap of making it intentionally complex because that will be counterproductive. So what's the idea then of these exception and defence and exclusion clauses and machinery provisions? Well, in short, they're a drafting technique that allows you to reduce the length and the complexity, therefore, of the legislation. And they're different things, but we lump them together because they serve a similar purpose of efficiency in the drafting of legislation. So when we talk about operative provisions and operative sections, these exceptions, defences and machinery provisions support the operative sections that we talked about earlier tonight. So what is an exception provision? So an exception provision is a provision that exempts a person or a class of people from a statutory provision. In other words, if something would otherwise apply except for the exception provision, then we have that mandatory requirement. So exception provisions provide the class where it doesn't apply. This act does not bind the Crown, for example. Number two, defence provisions. A provision which relieves a person from liability for a statutory offence. Number three, machinery provisions, which are, as the name implies, indicating practical things that need to be done to achieve the objects of an act. So machinery provisions often establish statutory duties, often establish statutory discretions. So a duty is something which is given to a public officer by statute. The duty is mandatory if the word must is used in most instances. A statutory discretion is, as we've talked about earlier tonight, where a public official has an ability to make a choice whether to do something or not. So it's discretionary in nature, and the key word there, of course, is may, but subject always to the commentary that I ran through from Pearson Geddes in Chapter 11. Now, machinery provisions are usually formal provisions or process provisions or authorising provisions or responsibility provisions. So we'll deal with those briefly now. So formal provisions are those that are required as a matter of formality for an Act of Parliament. For example, the short title. An Act has to have a name. So we call that a machinery provision, which is what we further describe as a formal provision. So given that there are 4 types of machinery provisions, number 1 is formal provisions. So even simple acts need a name, don't they? And usually that's a long title and a short title. We need commencement provisions and purpose provisions. Now, the second type of machinery provision that you might need to consider are process provisions. So the key here is to ask this question, what needs to happen? What process needs to be followed for the Act to be workable? So, for example, the Environment Protection and Biodiversity Conservation Act, 1999, it provides for the process of obtaining environmental approvals, and that runs for hundreds of sections. So when we talk about process provisions, it's not necessarily 1 or 2 here and there. It can be a whole bunch of provisions. The third type of machinery provision are authorising provisions. And this really answers this question. Who needs the power or the authority to make the legislation work? So bear in mind the principle of legality. You've got to set out boundaries and legal requirements. Number 4 is to do with responsibility provisions, which is who bears the responsibility overall, and to that person or that body can the power be delegated. So you have to think about administrative law principles as well. Now, I mentioned that a key resource is the Office of the Parliamentary Counsel. Let's go to that website now. I invite you to call that up. I imagine this is probably in your favourites by now. It's a very good website. So hopefully you can now see that on your screen. So the OPC website has some excellent resources. Tonight we'll be looking at drafting resources. And in particular, we'll look at drafting templates. Now, those templates are in Word version, or in the case of the user guide, in PDF. And there are several that you need to consider. I would start by looking at, apart from the user guide, I'd probably go down to the bottom, principal instrument. So this is a template for drafting a principal instrument, which might be legislative instruments or otherwise. So use this template for creation of the formal provisions and the process provisions that we've talked about. I have printed that or rather saved it. So I'll now see if I can move across to that, and you should have access to this in any event. And I'm not sure if I've got the right one here. We'll see how we go. So hopefully, therefore, you see this template, which is in Word version. And if we pan down, you'll see that it sets out the template for creating principal instruments. Legislation, in other words, at a Commonwealth level. So the instrument is then the name of the instrument. Then you've got the machinery provisions. This is all available as the template. And we have authority, definition, schedules, and other sections. Now, I think I've previously discussed that I wouldn't recommend necessarily that you follow that precisely, but it is an excellent resource. And just have a look at section 6, because it provides you with an overview of what we mean by a section, a subsection, paragraph, and subparagraph. All right, so that's a very useful template provision for you. Then have a look at authorization provisions and the template in relation to authorization. Again, I'll see if I can find that in the material. As you might guess, I've got a lot of things working on the screens that I'm using. So have a look for the authorization provisions. Now, this template provides for the granting of or authorising of power to individuals. Some rules there about ensuring that the authorisation is appropriate, and again, some pro formas that you might want to use. So the idea here with authorisation provisions, as I mentioned, is who needs power or authority to make the legislation work, and are they given their powers in a way that is mandatory or obligatory or discretionary. What you might do is have a look at Section 15 of the Enabling Legislation Act 2015, which is on the screen there. And you'll see the comment at 13 that generally authorisation is given to persons of particular class rather than named persons. The template is very useful because it provides that ongoing commentary. Not only does it set out the way in which the document should generally look, but it has the specific information relevant to the substance of the document to follow on from the form of the document. All right, so that is in relation to authorisation. We might leave it at that for this evening, and next week we'll pick up by looking at further templates and materials from the OPC website. Have a look at the template for delegation will be the starting point for next week. I'll stop the share now, and any questions, comments, or are we all good? All good? Okay. Thank you for attending. We'll see you next week, and all the best with your drafting. Bye for now.